Everyone, again, my name is Mike Esper. I'm the lawyer for the electoral board. I think we have a number of items to consider today. I think it makes the most sense if we take the cases slightly out of order and do cases 6 through 10. So Mr. McGrath will be on your way and not listen to discussion to follow. No problem. So the first case is case number EB006, SOVA v. Singh, S-I-N-G-H, SOVA is S-O-V-A. And the board members on that case are President Dominic, Mr. Baruso, Ms. Rex. So can we take attendance for that?
Mr. Kessler, yeah, a little hard, so I'm away from you.
Is my thing on? Is my thing on? Yeah? All right.
Words of wisdom and all.
Yeah, well, you can hear me without hearing any words of wisdom. The first case is SOVA v. Singh, EB006. The board members are President Dominic, Mr. Baruso, and Ms. Rex. So we need to take a roll call for that.
Claire Dominic.
Here.
Joe Baruso.
Here.
Here.
And we could call all of the cases involving the objector SOVA, because the issue is the same in all. Does anyone have an objection to that? No. All right, the second case is SOVA v. Benavides, EB007, where the board members are President Dominic, Ms. Wrights, and Mr. Cohen. We'll do a roll call for that.
President Dominic.
Here.
Randy's here. Mr. Cohen.
Here.
The third case is SOVA v. Garcia, EB008, where the board members are President Dominic, Mr. Baruso, and Mr. Cohen.
Roll call. Mr. Cohen. Mr. Russo. Here.
The fourth case is SOVA v. Rodriguez, EB009, where the board members are Mr. Baruso, Mr. Chair, Ms. Wrights, and Mr. Cohen. Roll call on that.
Baruso. Reed's here. Mr. Cohen.
Here.
And finally, SOVA v. Wells, EB010, President Dominic, Mr. Russo, and Ms. Rex.
President Dominic.
Here.
Baruso.
Here.
Thank you. Okay, so for purposes of these 5 cases, you're all aware that the records examinations begin tomorrow morning. Okay, so we'll deal with that in due course. I don't know how long it will take. Is it a slate petition or is it different? It's all different.
It should be done.
A day or two. Okay, so just consult the rules regarding filing proceedings you want to file afterward. So then the next thing to consider is the request for subpoenas from the objectors.
That's right.
Correct. And in each case, the objector has requested subpoenas of a notary public, a subpoena to a notary public.
That's correct, electoral board, for the notary public herself, testimony as well as relevant documentation, and then the other, the index sergeant of the public secretary of state, also related to qualifications.
Okay, and then there was a separate request for subpoenas related to residency for C.
Correct. No, a candidate Wells.
Oh, well, you're right. Items to discuss. And if you'd like, happy to tell you what I think, or regards to the notary public, would you like to make any argument with that, Mr. McGrath, or stand on the?
Just briefly, if I could, may. The objectors do subpoena requests. They are, they're really pled and sufficiently pled for in good faith in their objector's petition, in paragraphs 7 through 11. They have it cited in our subpoena request. Specifically, the objector, they allege that circulators did not personally appear for the notary and their swear or affirm their oath, as well as allege that the notary public notarized in its petition sheets for the circulators who did not personally appear before. Or this would violate the Illinois Notary Public Act as well as the allegations that violate the election code. These two subpoenas, they're not extensive. There's subpoenas for the notary public herself, as well as for documentation from the Illinois Secretary of State's office. The Secretary of State requests are relevant to the petition because we're seeking notary's application, identification queries, court certificates, signature assessment, and any other relevant documentation they may have regarding the qualifications and the notarial mission of the notary public. For those reasons, we ask the electoral board to grant our request for subpoenas on this matter. Thank you.
Mr. Mullin?
Thank you. So we objected to both of these subpoenas. As an initial matter, the candidates are all here willing to testify. They are circulators as well. So the allegation is that the circulator did not appear before the notary. There is testimony available to prove or disprove that allegation. What the objector seeks to do is to bring in notary public who they allege has inaccuracies and irregularities in the petitions that indicate to them that for some reason they don't believe that the circulators appeared before her. However, they did not indicate what any of those discrepancies or irregularities were. So if we're going to have the notary public who is not a candidate, not a circulator, someone outside the process who just comes in and notarizes a petition, bring anyone who is a notary public in to testify, that is, that is burdensome for someone who is a notary public, and unless they can show some probable cause why they believe that this notary public did not notarize things appropriately, then the subpoena should not be granted. Otherwise, we would bring in every notary and every circulator. It's not reasonable. Furthermore, with respect to the Secretary of State subpoena, the Illinois Election Code does not require full compliance with the Illinois Notary Act. The Illinois Election Code says you need to appear before someone authorized to take oaths in the state of Illinois. That doesn't require, there are cases where the notary has expired, all sorts of issues where there might be a problem with the Illinois Notary Act, but that's not an issue with the Illinois Election Code. So all of the information that's being sought from the Secretary of State is not relevant to the question of whether the circulators in this case actually appear before the notary. And so we believe that should be denied as well.
Okay, does anyone have any questions?
I have a question, and I hear a response.
Oh, sure.
Sure. Briefly, the response would be that the allegations would violate the election code and would result in the petition sheets that were notarized by the
objector's petition makes the assertion upon information and belief that the circulators did not appear before the notary. Do you have any more specifics as to why you have that belief?
That is the objector's belief. That's what our client informed us, that their good faith basis. Exactly what draft petitions and provide more direct answers as why this was sufficiently led. At this time, with the knowledge that I have, and it was pled early and as best it can, and should meet the pleading requirements.
Okay, thank you. Any discussion, any more questions?
What's your point of view about whether it meets the pleading requirements?
I don't, I think that there is case law that stands for the proposition that where fraud is brought to light at any point in the proceeding, it can be argued and pursued. I don't think there's enough now for us to authorize the subpoena to the notary public and Secretary of State. I'm not sure what the relevance of the Secretary of State documents are. Notarization is by design and by statute a self-authenticating act. And the whole purpose of getting a document notarized is to avoid the testimony that the objector received. So that's why I asked the question if they had a little bit more knowledge about it. And so my recommendation would be that we, at this point at least anyway, deny the request for the subpoena.
So move.
Second?
Okay, look, why don't we just call everybody and if everybody's in agreement, then we have to do it for each individual.
You can always bring it back.
Mr. Russo?
Aye.
Very good. Okay, I believe that concludes the items for cases 6 through 10. Is that true, Mr. McGrath?
That's correct.
Ms. Mullen, agreed?
Yes.
Okay. All right, so, good luck to everyone in the record exam tomorrow. Avoid fisticuffs if you can.
Thank you. Is there a date for return?
Oh, yeah, we should schedule that, maybe a week from today.
On the
Do you want to schedule an evidentiary hearing for then, or do you want to have status? I think we're confident that the records exam will become completed.
I think the records exam will be completed, and it's a 24-hour.
I believe that's right, yes.
I would prefer that we set it for hearing.
All right, well, let's set it for hearing. A week from today? That work?
How much time will we need on that day?
That's a good question. It depends on how close it is.
Well, the question then is, if instead of noon, do you want to start earlier?
Yes, that may not be.
And my other question is, what are we doing with respect to the motion to dismiss?
That's in next batch of cases. There is no motion to dismiss
Okay.
the case.
I would suggest that we start earlier than noon on the 9th.
How about 10 or 10:30?
10:30.
10:30, Mr. Mullen?
That works.
And,
Do you want an additional tentative date?
well, I think we should be there.
Okay.
Mr. Castro?
Yes.
Could we also set date for any disclosure of witnesses or affidavits prior to the 9th, maybe the 8th at 10:30?
24 hours in advance. Mr. McGrath?
I'm sorry, can you repeat?
They're both
With the hearing.
24 hours before the hearing,
Sunday,
disclosure of
10:30.
witnesses and affidavits and other evidence, other documents.
Fine.
Okay, agreed.
Thank you.
Okay.
Do we need a motion?
email service of evidence and I'll distribute it. Service via email of evidence, other documents is fine.
And that's just on the opposing counsel, or do you want a copy?
I think that way I can have exhibits prepared. Okay, thank you.
Thank you.
All right, now let's move on to the Vega cases. The first case is Vega v. Singh, EB 001, where the electoral board is Dominic, Veruso, and Wrights. Could we have a roll call on that?
President Dominic?
Here.
Russo?
Here.
Reed's here.
The second case is EB 002, Vega v. Benavides, Dominic, Wrights, and Cohen.
President Dominic? Reed's here. Mr. Cohen?
Here.
The next case is Vega v. Garcia, EB 003. The board is Dominic, Veruso, and Cohen.
Cohen. Here. Russo. Cohen. Oh, here. Sorry. Here. Dominic, here.
The fourth case is Vega v. Rodriguez, EB 004. Mr. Veruso. Ms. Wrights.
Here.
Mr. Cohen.
Here.
And the last case is Vega v. Wells, ED 005, President Dominic, Mr. Veruso, and Ms. Wrights.
Here.
Why don't we consolidate these for purposes of argument, so that you don't have to say the same thing 5 times. This case involves the sufficiency of the language of nominating petition. The candidates have moved to dismiss the objector's petition on the basis that the language used by the candidates both completely and substantially complies with the requirements of the election code. The objectors have responded and Mr. Mullins filed a reply. Does anybody have any preliminary questions?
I have one, and that is, am I correct that in 2017 and 2013, there was no consolidated primary election in February?
In 2017, 2013, I believe those are the dates that you had stated.
I said,
13 there was actually, there was definitely a primary in 2013 because it was a contested race, and there was also a general election. I believe that the dates were 2021 and 2017. I'm sorry, 13 there was definitely a primary. 2017 and 2021, I believe there was not a primary, and the reason was, as it was explained in our brief, the reason was because there was an agreement made between the Cook County Clerk's Office and the town board to not actually hold a primary because of the cost to the town and the cost to the taxpayers. Instead, parties agreed to move what would essentially have been the primary election, electing, the actual election that was going to elect the officers in the town. So they decided to move that to April. Again, that was more of a cost-saving measure. So that's.
I think the other date was 4 years. No, it was 2023, was it not?
Yes, 2023 was one of them. So I think, I
27.
have to double check my notes, but yes, there was at least 2, maybe 3 times that the town has agreed with the Cook County Clerk's Office.
17, 19, 21, and 23.
Okay, yeah, that was,
Years 2017, 19, 21, and 23.
yeah, all of those were uncontested. So because of that, again, it's a cost-saving measure. The town and the clerk had agreed not to hold the primary, which,
I'm sure the voters and the taxpayers appreciate saving that money.
yes, because I mean, well, as you know, to convene an election for even just one race, or, a couple races, that can become very costly.
Thank you.
Anything else, Mr. Cole?
No.
Anyone else? All right, Mr. Mullen, it's your motion if you'd like to address this.
Thank you. As I believe the board understands, this objection is solely to the language on the petition heading of each of the candidates that says they seek to be placed on the ballot at the consolidated primary election on February 25th of 2025. And if there is no primary election, they seek to be placed on the ballot at the consolidated election on April 1st of 2025. The objector has objected to this language based on specifications that were passed along with a referendum in the town of Cicero in 2004. The specifications were added to the objection as an exhibit, and there are a number of specifications that are relevant here. We believe, number one, that the petition heading tracks exactly the language of specification 1 and does not conflict with any of the other specifications that are relevant. We also believe that even if this was an incorrect statement of the election process in the town of Cicero, the precedent of Wiggins indicates that this is not a reason to exclude the candidates from the ballot. And finally, the third point that we make is that the issue of voter confusion is not relevant here because the question for the board is whether or not the petition headings comply with the election code and the other relevant law. So the first point is whether or not the petition accurately describes the election process in the town of Cicero. And I think to answer that question, the first place that you need to go is to specification number 1. The first couple sentences in specification number 1 talk about the immediate elections after the passage of the referendum, which did indeed pass in 2004. Then it concludes with the sentence that says the successors to those immediate elections shall be nominated at a primary election. So the language of the petition that candidates have say that they seek to be nominated at the primary election. And every fourth year thereafter, and in parentheses it says if a primary is necessary pursuant to the provisions of sections 3.1-25-20 through 3.1-25-55. If a primary is necessary, then it says, and they shall be elected at a general election be held at the consolidated election in 2005 and 2007 and every fourth year thereafter. So this language applies to this election because it's talking about every fourth year thereafter. And what it says is that candidates are going to be nominated in a primary election, they're going to be elected in general election, and that a primary election is only necessary pursuant to provisions of certain sections of the municipal code. The key one is section 3.1-25-20 of the municipal code. And among other things, what this says is that if there are no opponents to a single kit, then the primary is uncontested. And if the primary is uncontested, you move directly to the general election without having a primary. There is nothing else in the specification that conflicts with that, and there's nothing else in the specification that says that this provision 5 talks about what happens if there are multiple candidates and no candidate receives more than 50% of the vote, and then it moves to a general election with the top 2 candidates. Now, the objector has talked about the historical practice in the town of Cicero and their belief that there is supposed to be a primary regardless of whether it's uncontested or not. I would submit that the practice of the town of Cicero is not as relevant to the board as the plain language of specification 1. And when we talk about statutory interpretation, there are a lot of different principles of statutory construction, but one of them is that language is not superfluous, right? You don't include language in a statute or a referendum, and it's meaningless. So what I would ask is, if the language that says, if a primary is necessary pursuant to the provisions of section 3.1-25-20, if that does not mean what it says, which is that a primary is not necessary if a race is uncontested, then why is that language in specification 1? If you read it out of specification 1, you are rendering it superfluous, which is against the rules of statutory construction. So we believe that the language in candidates' petition headings is an accurate reflection of the specifications. The second point we would make is that if,
I'm sorry, can I interrupt?
yeah,
I'm just gonna try to cut to the chase. I couldn't hear. what
I
you
said, I'm just asking a question. If the candidates, the point that you're relying on, specification 1, candidates are nominated at a primary and elected at the general, right?
yes.
Specification 4 says that a person can be elected at the primary.
Yes.
How does that not,
How good?
Well, it doesn't,
how does that not conflict?
I would agree that those 2 provisions conflict, but it doesn't conflict with the question whether a primary is necessary.
Okay,
Because a primary would only be necessary if it was contested.
okay. That's where, okay. Your candidate forced the primary election by filing to run in. So there's going to be a primary, right?
Yes.
Yes.
Once the board votes to allow them on the ballot.
Right. By filing it, there's a presumptive primary, right? And no one filed to run against them. They'd be elected pursuant to specification 4, right?
Say that one more time?
If no one filed to run against them, they would be elected, not in April, but in February pursuant to specification 4.
I don't believe that's correct.
A person who receives 50% plus one of the total vote cast for his office in the nonpartisan primary election.
But that presumes that the primary election occurs.
You answer my question.
Okay. So the second point is, to the extent that the board, sorry,
I wanted to ask Mr.
and I'm having a little trouble hearing you. Thank you.
Okay, yeah, I guess we have to be close to these
Yeah, right.
things. I wanted to ask you about the hypothetical that you just asked. When would the person be elected if nobody filed against his candidates?
That,
February.
that is the parties seem to have a date about. not elected in February, but then has to appear again on the ballot in April. I won't speak for the objectors, but I think the objectors would say that whenever one candidate files for the primary, that triggers the primary. And if that candidate gets more than 50% of the vote in the February election, they're elected to the office. It doesn't carry over.
And so, and in your hypothetical, where nobody ran against his candidates, my question was, when are they elected? February 25?
Mr. Mullen claims that they're not elected till April.
Is that your position?
Correct, based on, so specification 1 incorporates section 3.1-25-20, which says there's only a primary if the race is contested. It's uncontested if there's only one candidate, and if it's uncontested, the candidate is placed on the general election ballot.
And how do you differ, how does your view differ from his?
Well, I'd like to hear from the
Okay,
other side.
that's fine.
Okay, go ahead, Mr. Mullen.
Sorry. So the second point is, to the extent that the board disagrees that the heading was drafted in compliance with the specifications, the Wiggins case, which is the only case that has been cited on this issue that's binding precedent on the board, indicates that statement of the wrong election is not a basis to exclude candidates from the ballot. And the Wiggins case was not simply about someone putting in the wrong date, putting in February 27th or 2024 instead of February 25th, 2025. The candidate in Wiggins put the April 1st election date as the date that they wanted to be on the ballot, and the objector argued that the candidate was trying to bypass the primary election by putting that on his petition. And the court said that is not a valid objection because there's only one election, and the election is governed by statute. And so as long as the candidate had indicated the consolidated primary election, which the candidature do, that was sufficient. The third issue that's been raised is the issue of potential voter confusion. And the first thing I would say about voter confusion is never in any of the cases, electoral board, appellate court, or otherwise, the issue of voter confusion has never been applied to the question of the election date. And the reason for that, I believe, is that the election date is not one of the mandatory requirements of section 10.4, which governs what is required to be in the heading of the petition. It talks about the name, the address, and the office. And so there are a lot of cases that talk about confusion with the office that the candidate is seeking, but there are no cases talking about confusion by the voters with the date of the election. And the reason for that is because it's not a required element of section 10-4 of the Illinois election code. Beyond that, there are a couple other principles that I think are important. The first is the question is whether the nominating papers as a whole are confusing. And the statement of candidacy here says that candidates seek to be placed on the ballot for election at the consolidated primary in 2025. And so looking at the principles of Lewis v. Dunn, there is clarity in the nomination papers as a whole because both the petitions and the statement of candidacy say that the candidates seek to be placed on the ballot at the consolidated election on February 25th. If there is only one election on February 25th, then the rest of the language it's not conflicting, it's just unnecessary. It doesn't change anything about the way the election is conducted or when the candidates are placed on the ballot. But one of the other important principles is that the concept of confusion has only been applied where there are two possible choices that are the Neal case, for instance, on the petition, there was a reference in one part of the petition to Oak Park and in another part of the petition to the town of Cicero. And so both of those options were realistic possibilities for what the candidate could have been seeking. And so the court found that there was irreconcilable conflict because there were two potential choices. And that's true with a number of the other cases where, there was two things that the petition could be referring to, and so there was a potential for confusion. Whereas here, there is only one municipal election. And if you look at the Pescenti case, it talks about the idea that if there is only one possible thing that the petition could be referring to, that you can't have confusion because there's only one possibility. And here, there's only one municipal election in the town of Cicero in 2025. So there's only one thing that these petitions could possibly be referring to. The issue of actual confusion is irrelevant because as a matter of law, they are not confusing because there's not more than one choice. One other point that I would like to make that wasn't in the briefing is that the objector appears to acknowledge in their opposition that they're not really alleging a violation of Section 10-4 of the Election Code. And so in the Wiseman versus Elward case, which is a First District Elward case, which is 5 Illap 3rd, 249 at 257, talks about the scope of the authority of an electoral board. And what it says in relevant part is referring to Section 10-10 of the Election Code, which creates the electoral board. It says, quote, "We interpret this provision as limiting the electoral board's scope of inquiry to the sole issue of whether a challenge nominating petition complies with the provisions of the Election Code pertaining thereto." So what objectors arguing is that there's something relating to the petition that is confusing but doesn't violate the Election Code. I would submit that that's outside the scope of the authority of the electoral board because the board's authority is limited to determining whether or not the language of the petition heading complies with the provisions of the Election Code. And for those reasons, we would ask that the objector's petition denied as a matter of law.
Thank you, Mr. Mullen. Any other questions? Mr. Morrison?
Thank you very much. Can everybody hear me okay? Okay, so the first thing to point out is Cicero is different. Cicero has a unique system of elections that was adopted in 2004, somewhat modeled after the Chicago form of elections, which I believe many people on this board are probably familiar with, where in Chicago, there's always a primary election. There's sometimes a general election. That was the intent behind this referendum. That was the reason behind this referendum question. That was what the board did when the board approved this referendum to go on the ballot back in 2004. The intent was to model.
I'm sorry, may I interrupt with a question? You said that Cicero is unique
Yes,
because of this referendum.
correct.
Explain to me, I'm inexpert in municipal law, why is it, let me, particular, this business about someone filing in the primary in any other town that hasn't adopted the system besides Chicago, which is one. Someone files in the primary, absent this referendum, and runs uncontested, what happens?
So absent the referendum, if we're just looking solely at the operation of the municipal code, then yes, the primary would not occur if it's an uncontested race, and those candidates would then appear on the general election. And that's in a case where we don't have this referendum and these specifications that are similar to the city of Chicago's system of election.
I'm sorry.
Oh, no problem. So as I was saying, Cicero is unique. Cicero is unique for many reasons. Number one, Cicero was established via town charter. And Cicero has its own way of doing things. and doing some way of doing many things. And one of the ways that Cicero does different, or one of the things Cicero does different, is its elections. And again, Cicero back in 2004 approved a referendum, the Cicero Town Board approved a referendum, placed it on the ballot for the voters to determine, do we want to do our elections differently here in the town of Cicero? And the voters overwhelmingly said yes. So now we've got this unique system of elections that doesn't exactly jive with section 10-4 of the election code. However, just to respond really quickly to the point that Mr. Mullen just made when he was doing his portion of the oral argument, when he was talking about the jurisdiction of the electoral board, the applicability of section 1010 of the election code, just to respond to that, he is correct that the electoral board is foreclosed to interpreting election laws. However, in Cicero, the election laws also encompass the referendum and specifications. And where there's a conflict between the referendum and specifications and the general election laws of the state of Illinois, the Cicero referendum controls. And that is based upon just general principles of statutory construction. You've got a general provision versus a specific provision, the specific controls. Another general principle of statutory construction that I'd like this board to keep in mind is that, yes, while you have to give meaning to every word in the statute, you also have to read the statute or the legislative document that is in front of you that is governing that process. You have to read that as a whole. You don't read it in bits and pieces and cherry pick certain language that you think actually works for you. You need to read it as a whole. So what does paragraph 1 do? Paragraph 1 basically says, hey, we're going to change our system of elections. As a general rule, if people file, there's going to be a primary, and then there's going to be a general election. The references to section 3.1-20, -25-20 and 3.1 to 25-55. Those are simply saying, okay, here's how the elections are performed for most nonpartisan elections in a municipality. However, again, where there's a conflict, these specifications would control. Paragraphs 2 and 3, well, yes, they do have some limiting language in there related to the office holders. Those paragraphs are still fair, they're illuminating. They're letting the current office holders know, listen, things are changing in Cicero. You are not going to be elected to general election anymore. You're not going to run in a partisan primary any longer. You are now going to be elected in February, and unless a runoff is necessary, you will be elected in April. So those paragraphs are advising the current office holders of, hey guys, this is how it's going to work moving forward. Then we look at paragraphs 4 and 5. 4 and 5 make it abundantly clear that if a candidate receives 50% plus 1 in primary, that candidate then goes on to be a winner, period. The only time that the general election occurs is where there's a runoff election and somebody does not get that 50% plus 1. Now, the question, of course, came up of, okay, what happens when it's an uncontested race? It's very clear by both the practice as well as the practicalities of this referendum and these specifications. It's very clear that the candidates who are running uncontested actually are supposed to run in February here in Cicero. And again, that is because of the unique system of elections that was adopted through this referendum specifications. 3.1-25-20 through 25-55 do not provide any sort of illumination to this specific issue. We have to look at the actual referendum itself. And we have to look at the wording of the referendum that does state that if somebody has 50% plus 1 in primary, they are elected. In an uncontested race, there is nothing in this referendum that says uncontested races will result in the candidate being on ballot only in April. There's absolutely nothing in this referendum that states that. And again, the practice and the interpretation, not only of town of Cicero, but also of the Cook County Clerk, has been that a February election is necessary. And honestly, I think who better than to ask in a situation like this than the people that helped put this referendum question on the ballot. Many of which are sitting on the board today. They understand what their concerns were and the way that they wanted the elections to operate in the town of Cicero. And this is the way that not only board, but the people of Cicero determined that they wanted to operate the elections. They wanted their candidates elected in February if possible. If they're uncontested, they're elected in February. If they win the 50% plus one, then they're elected in February. Unless there's a tax saving agreement that can be entered into between the county and town, which has happened and I double checked the election results. It actually did not happen in 2021 and 2019. It did happen in 2023 and 2017. And the reason it didn't happen in 2019 was that there was actually a contested race, so there was a primary. There was between some of the trustees. And then there was obviously a general election after that. In 2021, the reason for it, if memory serves me correct, again, was linked to the uniqueness of the Cicero system of elections. And why I say that is because in 2021, there was a group of candidates that had filed to be write-ins. Well, there was a case that was brought to contest their ability to be write-in candidates in the town of Cicero due to the unique system of elections in the town of Cicero. Ultimately, the electoral board determined that Cicero did not allow write-ins. That went up to the circuit court. The circuit court agreed and said that the system of elections in Cicero does not allow for write-ins. So eventually, the town of Cicero, to allow for write-ins, actually had to pass another referendum to amend the system of elections to allow for write-ins. The reason I bring this up is this again shows the unique nature of elections in the town of Cicero. As a home rule community, Cicero is allowed to determine, via its voters, how it wants its elected officials elected and how it wants those candidates, how and when it wants those candidates elected. The town has made that determination. And the town has said, as a collective, the electors of the town have said, we want our candidates to appear on a primary ballot and, if necessary, appear on an April ballot. Now, Candidates Council also talks about voter confusion and how there can be voter confusion because there's really nothing to be confused about. Well, again, in my opinion, that is incorrect. There are two elections that occur within this cycle. Telling the voters on a petition page that there might not be a primary could definitely have an impact on voter turnout in the town of Cicero. The town of Cicero, just like many communities in Cook County, suffer from low voter turnout. Something like that could impact voter turnout even more. There are clearly two elections that occur within an election cycle. And so there is a basis for confusion. And obviously somebody was confused, signed an affidavit to state, in fact, I'm confused, I don't know what's happening here. I don't understand how this petition actually complies with how elections work in Cicero. They didn't realize that there was going to be a primary. They just thought that there was going to be a general election. That in and of itself shows actual confusion, not just potential confusion. But there is potential for confusion, regardless. Regardless of the affidavit that was submitted, there is the potential for confusion because, again, Cicero has a unique system of elections. And in addition to that, given Cicero's unique system of elections, some of the case law that has been cited by Candidates Council really is not applicable. Section 10-4 does not apply square on its face to the Cicero system of elections. It gives us some information as to what generally is required in a petition. Now, we have never stated that the date of the election is required in the petition. I, in fact, agree with Candidates Council that the date of the election technically is not required in the petition. However, once you put that information into the petition, you then create the confusion. And that's what the Neal Court was concerned with, was additional information, irrelevant, contradictory, and incorrect information being put in a petition so as to confuse the electors. And the elector in this case has been confused. We have an affidavit to that effect. And I do believe that there is a strong potential for confusion given the unique system of the elections in Cicero. And that's what I really think we need to focus on, is that this isn't per se the city of Chicago, even though the city of Chicago's, even though this motto somewhat after the city of Chicago system of election, with some minor changes. This isn't a general nonpartisan election that is governed by the Illinois Municipal Code. This is the town of Cicero.
I have, obviously, more about the general municipal election law?
Sure.
How many candidates necessary to trigger a primary election?
Four.
Four. Agreed, Mr. Mullin? Outside of just more than four. More than four. More than.
Or I thought it was, yeah, more.
It's more than four.
And then what happens after, what's the winning process?
So there would be a primary with two, with all of the candidates and the two, as well as the other group on the general election.
Regardless of whether or not one of them got more than 50?
Correct.
Yes, that is correct, unless you live in Evanston.
Which again is allowed to have its own unique system of elections. That just highlights the fact that, there are different towns, there's different communities that do it a little bit different. If you're a home rule community, you're allowed to do that. And Cicero determined back in 2004, 2004 when it put the referendum question on the ballot, in 2005 when it was approved, I'm sorry, strike that, it was actually approved in 2004. Cicero determined that it wanted to do elections differently. It didn't want to follow the model that was under the municipal code. It didn't want to have to wait until there's X amount number, 4, 5, 6, 7, 8, 9, 10 candidates to hold primary. It wanted to hold the primary, whittle down all the candidates right then and there, and then just have a runoff election between the top two vote-getters. And if there is no top two, or in the alternative, if somebody gets 50% plus one, they are deemed elected. And again, this is how Chicago worked. If we all remember, Mayor Daley was constantly getting that 50% point one, so there was almost never a general election. My entire life growing up, I don't really remember a general election until much later, until, we had Rahm Emanuel who had to run in a general election because he didn't get the 50% like one in the primary. And those petitions, I don't know what those petitions said, and to be quite candid, they're kind of irrelevant, but these petitions here, the town of Cicero, need to inform voters as to how the elections work in Cicero. These petitions do not do that. They give misinformation to the voters. They tell the voters there's definitely going to be a general election. There might be a primary. How is that going to impact voter turnout? Especially in a community where we already have not that high voter turnout. And I think that that's a very serious issue that needs to be understood. And I think that's when you look at this, again, we can't just look at the referendum in a vacuum. We have to give credence to all of the provisions of the referendum. We have to give weight and importance to all the provisions of the referendum. And at least 3 times in this referendum, both in section or paragraphs 2, 3, 4, and actually 4 times if you look at 5 as well, it states that candidates are elected in the primary if they get the 50% point one or plus one. If they don't, then there's room. It really couldn't be clearer. And petitions do not reflect that. Petitions reflect the exact opposite. Petitions instead basically rely on the general language of the Illinois Municipal Code. They appear to track the petitions that are general nonpartisan primary petitions that are found on the Illinois State Board of Elections website through the candidate guide. But again, those petitions do not take into consideration the unique system of elections here in Cicero. And, I do think that the history behind this is important. We need to give weight to the intention of the town board. When we put this on the ballot, we need to give weight to the intention of the voters when they approve this referendum project. They did not want it where there was going to be possibly a primary, but definitely a general. They wanted it where there was definitely going to be a primary, possibly a general. Yeah, I really think it could not be clearer. And again, with relation to the Neal versus Cook County Officers Electoral Board case, I think that the quote from that case that says, the courts and the board should not ignore erroneous or inconsistent assertions in nomination petitions, even when we believe we can determine which assertions the signers intended to make and which they did not intend to make. We have that here. We cannot ignore these inconsistent assertions that are inconsistent as it relates to how elections work in the town of Cicero. So in my opinion, there is no substantial compliance. There's no actual compliance. The candidates are trying to impose case law from Section 10.4 that is really inapplicable here because of the unique system of election that Cicero has adopted. not be required by section 10-1. The candidates put that in place by putting it on there. By putting that erroneous information on there, the candidates put this issue in play. It's not the objector's fault. It's not the town's fault. It's the candidate. Candidates put that information in there, which was not correct, not accurate, erroneous, could lead to confusion, and did actually lead to confusion. Let me just double check my notes really to make sure I address all my points. Yeah, it is clear from looking at all of this that the candidates relied likely on the Illinois election code in and of itself. They relied probably on the Illinois or state board elections form documents in and of themselves. In my opinion, there looks to be a complete failure to review the specifications of the referendum that govern elections here in the town of Cicero. There's also a complete failure to look at history regarding the elections in the town of Cicero. In both 2023 and 2017, the town made an agreement to not hold the primary election, and it's a cost-saving measure, and adopted legislation to that effect, which was done at an open meeting, documents that are available to the public. And, at open meetings, there has to be an agenda posted 24 hours beforehand. So public notice was given. All these documents are available to the public. Now, truth be told, this was just not done correctly. This was not done in compliance with neither past practice nor the actual language of the referendum and specifications. And as such, it is our request that the candidate's names be stricken from the ballot.
One last question.
Yes.
Do you know, either of you know, how many candidates are in each race?
There, if the candidates here are excluded from the race, every race will be uncontested.
So that means there's two today.
Yes.
So your position is,
Yes.
there's no primary.
No, my position is there is primary here.
I thought you just said you needed 4 to trigger the primary.
You asked a different question, sorry. Under section 3.1-25-20, it says it's uncontested if there is only one person running for the race.
Okay. Agreed?
Under the municipal code, there needs to be more than 4 candidates. In Cicero, in my opinion, there's always primary, whether there's 1 candidate or 4 candidates, because of the operation of the referendum question.
So, Mr. Mullen, let's say there were 3 candidates.
Pardon?
Let's say there were 3 candidates.
Well, can you give me just 1 second? I want to.
Sure, sounds good.
The specifications in Berlin refer to one statute, and the specifications in Cicero refer to a different statute. I just want to make sure I've got the right one.
And can I add one quick thing? As it relates to the Illinois Municipal Code and the provisions in the Illinois Municipal Code, those provisions also allow for write-ins. 4 years ago, Circuit Court, as well as this electoral board, determined that that also didn't apply. Write-ins were not allowed in the town of Cicero because of the unique system of elections. So, and I believe Mr. Mullen was on that case as well. So this is, it's very clear that both the town of Cicero as well as the courts use Cicero's system of elections as being unique. I just wanted to add that little thing to it.
All right, so my question is, if there's 3 candidates,
Right, so I pulled that up. Section 3.1-25-20 of the municipal code, which is the one that applies for the specifications, says no primary shall be held in any village, and the nomination for every office to be voted upon by the electors of the village is uncontested. If the nomination of candidates is uncontested as to one or more but not all, then a primary must be held. And it's an office is uncontested when not more than the number of persons to be nominated to the office have timely filed valid nominating papers. So if there's one vacancy and one person files, it's uncontested and there's no primary. If two people file, there is a primary, according to this.
In your view, then, if three people file for the primary and no one gets 50%, then what happens?
Then you look at specification 5 and do what it says to do in specification 5.
So then, your view would be that if your candidate, your client filed unopposed, not be elected in February.
Correct.
So your view then is this city's been doing it wrong.
I'm reading the exact
Good
language,
question.
right?
That's a
Yes,
legit-
yes,
yes, yeah.
that is my belief, and it may be that that was the intent, but that's not what the language says. And will I have an opportunity to reply? I've got
Oh,
a
yeah,
couple
sure.
points I'd like to make.
Absolutely.
Okay, thank you. So the first thing this council said is you have to look at the referendum itself. And that is exactly what we must do. And the referendum itself in the specification says, if primary is necessary, pursuant to the provisions of section 3.1-25-1. So the language of the specification itself, which was voted on by the people and read by the people, says if a primary is necessary. So if it were true that a primary is always necessary, why does the specification say if a primary is necessary? And it refers to the municipal code section that I cited. Then under specification 2, it says all office holders whose terms expire.
Primary is not always necessary. Primary isn't always necessary. What if your client filed and ran unopposed? Then there
We would still put them on the ballot.
Council, what's your,
They would be voted on.
what was your question?
If the candidate files and is unopposed, then there is no primary election.
That's my point.
Right. Under this provision here. Right, I understand.
So if there's no primary, then they would appear on the general election. And so specification 2 says that all office holders whose terms expire in 2005 shall be nominated and elected pursuant to the above sections of the municipal code. So it's not just saying they should be elected pursuant to the specifications, but it says pursuant to the above sections of the Illinois Municipal Code, which includes the language of an uncontested primary. 3 says the same thing. It refers to the above section of the Illinois Municipal Code. So there are 3 places in these specifications that say that you look to the terms of the Illinois Municipal Code, which say that the primary is uncontested and not held if there's only one person running for one seat. There's nowhere in this language that says in every election there will be a primary. I did not hear any argument that there's some language
if I may, as I had alluded to earlier, the town of Cicero adopted, because in 2021, the courts determined that write-ins are actually not allowed in the town of Cicero. The town of Cicero thereafter adopted a referendum to allow for write-ins and provided a system for write-ins. I don't have I can probably pull a copy of that from online or something. But if memory serves me correct, when that was approved after the 2021 elections, after, again, court had determined that there was no write-ins allowed in the town of Cicero, I do believe that a primary actually would be triggered if somebody filed for a write-in under the provisions of the write-in requirements for the town of Cicero. So, again, this goes to the uniqueness of the Cicero elections, where we can't just turn to cases interpreting the Illinois Municipal Code and cases interpreting the Illinois Election Code, because those cases don't always apply, because Cicero is unique.
Right, Mr. Cohen, perhaps, I'm telling you something over here, I apologize. The term write-in, as used in Illinois law, is a bit of a misnomer. You have to file a paper to be a write-in candidate first. You know, there's actually, for those of you who may be interested, it's scholarship on this question. The number one vote-getting write-in candidate,
Mickey Mouse.
Donald Duck.
Yeah.
The history of America, the number one vote getter.
But it didn't count, see, yeah.
Good thing he's not in the town president.
Well, the reason I asked that was because in your hypothetical, I wanted to be sure that you noted that,
The big deadline for write-ins too is
I think it's 30 days before the election. I believe
It
60.
depends, if somebody's
It's
removed from the
December
ballot, it's up to 7
19th for this
days.
cycle, so whatever that is, back.
Yeah, but if someone's removed, they have up to 7 days prior to the election to file for a write-in. There's
So that's
different,
60.
there's a few different provisions in the election code and the Illinois Municipal Code that deal with write-in candidacy, so you really have to look at, is it a write-in primary level? Is it a write-in at the general election? And is it a write-in just for somebody who didn't file petitions? Or is it a write-in for somebody who did file petitions that was ultimately removed from the ballot? So there's multiple different quote-unquote schemes, if you will, for write-in to file for candidacy in a normal municipality. But again, Cicero is not normal, so it's unique.
No,
Cicero has its own way of doing elections.
Cicero's election for April is usually the school board, library board, and park district.
Correct, and that's exactly why
Right.
in 2023 and 2017, why Cook County Clerk and the town of Cicero thought it was a good idea to save some taxpayer dollars rather than have to hold a February election and then also have to hold an April election for all the other offices that are elected within the municipal boundaries of the town of
Okay,
Cicero.
all right, if just sum up, I think, getting into the right, we're getting a little far afield. I think I understand the dispute. I believe, Mr. Mullen, you're suggesting that if your candidate were to run unopposed in the February election, he would not be elected in the February election, but instead would go to April.
Correct.
But since there's two candidates, if he prevails with more than, since he'll get more than 50% presumably, then he will be elected, right?
Yes.
Okay, and your position is, under both circumstances, opposed or unopposed, that candidate is elected in February.
Yes.
That's the dispute. Fair?
That's the dispute about whether or not the language is correct, yes.
Right.
And to be clear, that's what the statement of candidacy says as well.
Which then creates some further confusion with the petitions.
Sorry,
Sorry.
sorry, you asked a question at the end of my first point, I just had,
Fine. Keep it on.
so, counsel for the objector is also trying to compare this to Chicago election. In Chicago, in February, it's the election, and in April is the runoff. Here, in Cicero, they call the February election the primary, and
considers its election to be the primary. The language in the referendum, I believe, is pretty clear on that, but I think that this is very supportive of that position. I just wanted to point that out, and I can circulate a copy of the referendum to the board and Mr. Mullen. That was approved by the town and ultimately approved by the voters as it relates to write-ins, if that would be a benefit to the board.
Okay, thank you, Mr. Mullen. Okay, so there's the question, motion by the candidates to dismiss the objector's petition. Anybody has any more questions? Now is the time, or any discussion? The options available to the board are to vote today on the motion. If it prevails, then the case will be dismissed. If the motion is denied, then I think we would have to turn to the question as to whether or not it would be an evidentiary hearing regarding voter confusion necessary. That would be the next step. The third step, the second option is to take the matter under advisement if you want to think about it. Those are sort of the options.
We should wait till ballots, handwriting.
I'm sorry.
If you want to come back.
Right.
Is this on?
Yeah, this is on the record.
I didn't hear, I'm sorry.
Could you repeat that?
I want to wait to see the signatures from the county mentioned petitions.
So I believe that is a motion to recess until, when did we say? The ninth, well, or no, the ninth, sorry, the ninth, 10:30. Take it under advisement.
I'm sorry, I didn't hear. I
He
didn't.
said if that's a motion and second, he'll second.
I'd like to ask Mr. Casper, what's the significance of that? Difference to make whether we vote now or on the 9th?
Oh, I think legally, it doesn't make any difference. If some of the board members want to think about it, reread the pleadings, consider it. There's also a possibility, given that the previous 5 cases, it could move this case. If the candidates all come in under the statutory minimum number of signatures, then this case would be moved.
I don't see any downside to voting on it now. That's
Other than if there's a desire to find out whether or not the case would be mooted, I mean, I'm sure some of the board members be welcome, being relieved of the burden of making a decision. So, I think that's probably in order, given your comments, but recess, and we'll take up the question.
okay. Is that a motion from you?
Yes, sir.
Okay.
Okay. And a second from Mr. Bruce. All those in favor say aye.
Aye.
Thank you all, thank you for your time.
I think, Casper, would the board also like me to distribute the write-in referendum?
Yes.
Yes, okay. I will get a certified copy of it, and I will distribute it to Mr. Mullen as well as the board.
That was helpful to raise that issue. I wasn't aware of it.
Thank you.
Yeah,